In this module, we will discuss propensity evidence in sexual assault and child molestation cases. In 1994, Congress enacted 3 evidentiary rules, Rules 413, 414, and 415, as exceptions to the character propensity ban. These rules essentially allow prosecutors and civil plaintiffs to offer evidence of the defendant's other acts of sexual molestation or sexual assault on any matter that is relevant. If the prosecution wants to offer this evidence, it generally must disclose it at least 15 days in advance. Now, must the prior offense of sexual assault have resulted in a conviction? Interestingly, no. Evidence of an uncharged crime as well as a conviction would be admissible under this rule. In essence, Rule 413 has 4 requirements. First, the court must find that the defendant is accused of sexual assault now. Second, the court must find that there is proffered evidence that the defendant committed another offense of sexual assault. Third, that other offense of sexual assault must be relevant to the current case in some way. And fourth, the notice requirements must be satisfied. Now, Rule 414 is a very similar provision. It relates to evidence of similar crimes in child molestation cases. It has essentially the same requirements as Rule 413, except instead of sexual assault cases, it relates to cases of child molestation and offers a definition of child molestation in Rule 414d. Last but not least, Rule 415 concerns evidence of similar acts in civil cases, not criminal cases, concerning sexual assault or child molestation. And in essence, the rule provides that in a civil case in which relief is grounded on a party's alleged commission of conduct constituting sexual assault or child molestation, evidence that that party committed another offense of sexual assault or child molestation is admissible and may be considered basically as provided in Rules 413 and 414. Now let's turn to some of the rationales for these rules. After all, we've spent ample time discussing the problems with character propensity evidence, how character propensity evidence may have a huge risk of unfair prejudice and carry with it little probative value. So what might be the rationales for creating exceptions to the character propensity ban in sexual assault and child molestation cases? Well, principally to protect the public from crimes of sexual violence, to protect women and children in particular, and also based on the idea that there is a high recidivism rate in sex cases, especially child molestation, and therefore evidence of a past crime has tremendous probative value on whether or not the person committed the current crime. The second justification that's often cited is known as the bolstering rationale. That is, in sexual assault cases, and especially child molestation cases, the credibility of the victim is critical. Knowledge of past rape cases, sexual assault or child molestation cases might be critical in bolstering the credibility of these victims, whose stories might not necessarily hold up under heated cross-examination. I should note, without going into it too much further, that these justifications are rather controversial, and in particular, there is some social science evidence suggesting that the recidivism rationale is not borne out by the numbers. The last point I want to make is the rules state that this evidence is admissible on any matter that is relevant. The phrasing "is admissible" here makes it unclear whether or not Rule 403 applies. Most of the rules use the phrase "may be admissible," which is a signal that Rule 403 is still in play. While these rules have not been corrected, the majority rule in the courts is that 403 does apply to Rules 413, 414, and 415, despite the somewhat ambiguous language contained in these rules.